doesn't involve racial profiling. And by racial profiling, I don't mean that the statute could be used disproportionately against members of a particular race, because every law could be used that way. And so to me, that's not a particularly interesting possibility. It doesn't differentiate SB 1070 from any other criminal law. However, SB 1070 actually authorizes in text racial profiling. It says that the police can't consider race, color, or national origin, except as permitted by the United States or Arizona Constitution. And most defenders of SB 1070, some of them impose, they just do the first part. Police can't consider race, color, or national origin, period. And the exception disappears from their description of SB 1070, which is extremely intellectually dishonest, in my opinion. So the first thing is that, I hope you see, even most of you are non-lawyers out there, but I hope you see that the very fact that there's an exception means that it's not an across-the-board prohibition. Why have an exception if you mean it to be an across-the-board prohibition? So Governor Brewer and Senator Russell Pierce, who were major supporters of the law, say that it's a flat prohibition, and I frankly do not understand why they would say such a thing when the text of the law has this exception. The exception is animated by the fact that both the U.S. and Arizona Supreme Courts have determined in unanimous decisions that race is a permissible consideration in immigration enforcement. So the U.S. Supreme Court said, the likelihood that any given person of Mexican ancestry is an alien is high enough to make Mexican appearance a relevant factor. And they said that in a case called United States versus Brignoni-Ponce, 422 U.S. 873 at pages 886 to 87 in 1975. The Arizona Supreme Court, in a case called State versus Graciano, said enforcement of immigration laws often involves a relevant consideration of ethnic factors. So the text of the statute says that consideration of race is permitted whenever it's permitted by the U.S. or Arizona Constitution. The relevant Supreme Courts have said that it's a relevant factor, not the only factor, but it's a relevant factor in determining whether someone is in the United States unlawfully. So it authorizes racial discrimination, authorizes racial profiling. Maybe it requires racial profiling because I told you that if a law enforcement agency says, hey, we don't check the immigration status of victims and witnesses, well, that subjects them to the suit. If they say, we don't consider race when we do immigration enforcement, well, does the federal law allow you to consider race? Yes, it does. So now they're enforcing federal immigration law. They're ordering their officers to restrict immigration enforcement to a lesser degree than that permitted by federal immigration law. So maybe they're subject to a suit. How are we doing on time?
What time is it? Yeah.
So let me give you the core constitutional problem here. There's two levels. One is federal immigration law is outlined and controlled by something called the Immigration and Nationality Act. And the text of that act assigns to the Departments of Homeland Security, State, and Justice responsibility for applying the act. It doesn't mention anything about the states. The substance of the act says that there's a variety of responses to undocumented people who are found in the United States who have no legal claim that they are citizens or that they've been admitted as immigrants. They can be charged with a crime. They can be civilly deported. They can be subject to a civil money penalty instead of being charged with a crime. or instead of being deported. They can be granted a form of legal relief called voluntary departure, where they're not deported, they're not charged with a crime, but they are required to leave within a certain period of time. 30 days, 365 days, and it has different legal consequences for being deported. That's the bitter part of the Immigration and Nationality Act for undocumented people. There's also the sweet. There's a series of forms of relief that are available to people who have no legal claim to be in the United States. There's a series of visas that are available to many of the kinds of people who we're talking about here. Victims of violent crime, witnesses in criminal cases, and people who've been trafficked. And particularly these days, as we heard from Frank, many of the people coming across the border, because it's so horrible now, they rely on professional traffickers, professional guides, as opposed to being the type of thing where you can just do it yourself. So there are these potential visas that are available. There's asylum, which is authorized by the Act. There is a form of relief called registry, which is available to people who have been in the United States for a very long time. There's a form of formalized prosecutorial discretion, which can come with work authorization, called deferred action, where you have no claim to a visa, you have no claim to asylum, but the Attorney General still says we're going to let you stay. And a lot of the people, of the kids who've lived here a long time and are now in higher education, MEMAC students, are not being deported based on getting deferred action relief. So there's this whole range of responses that the Immigration and Nationality Act assigns to federal authorities, from prison to you get to be on a path to citizenship. And it doesn't, the Act doesn't say to the states that you have an involved in this. And there's this doctrine called preemption that says that state laws are invalid if they interfere with federal regimes. And this one interferes with the federal regime because it allows the state to say, we want to put you in prison, when the people who have actually been assigned by law the decision, the federal authorities, might say, you know, we want to put you on a path to citizenship. We don't want to put you in prison. So I think the whole thing is ill-conceived. The mirror image theory, the idea that, you know, what's wrong with us helping you enforce your own law? Well, the answer is it's kind of a complicated law that involves a lot of different factors, a lot of different discretion. Arizona doesn't claim that it can issue its own asylum. You know, we're going to help you enforce this. We're going to do all of this. We'll put some people in prison. We'll give some people citizenship. They clearly can't do the visas and the asylum and the registry and the deferred action. They say, but we just want to do this part, the put them in prison part. And that's not the system. That's not what the Immigration and Nationality Act does. And so I think the trial court was not only right, but didn't go far enough in saying that most of what's going on here, not everything, but most of what's going on here is an interference with the federal scheme. The part that I don't think is an interference with the federal scheme is the arrests. That's not really directly authorized by SB 1070, but the history of allowing arrests by local police. Why? Well, because if the local police make an arrest and they turn the person over to federal authorities, the federal authorities still have the complete ability to run that spectrum of